I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground and then had the gall to post another video of it on TikTok. This is not a one-time mistake. As I sit here today with the information I have, I cannot in good conscience let this just get swept under the rug.
Before we step into this courtroom, here's why this case has everyone talking. An 18-year-old defendant is accused of brutally attacking a 14-year-old who, according to court records, was already curled up in a fetal position. Prosecutors also allege another video was later posted to TikTok with the caption, "Round 2." But this hearing isn't just about the assault, it's about whether the defendant deserves a second chance through a delayed sentence agreement. At first, both sides support the deal. Then everything changes when the judge signals he may reject it. Should rehabilitation come first, or does this case deserve a tougher response? Let's break down every key moment.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement, and what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence, and if you're successful with that delay of sentence, the case would be dismissed. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Let's pause here because the legal language can be confusing. A no contest plea is not the same as admitting guilt. Instead, the defendant chooses not to contest the allegations, allowing the judge to find her guilty without requiring an admission that could later be used against her in a civil lawsuit. That's why the Judge Wiggins carefully explains the possibility of civil liability. The alleged victim could potentially pursue damages in civil court, and this plea helps limit the defendant's legal exposure there. The other key issue is the delayed sentence agreement. If accepted, the defendant would have to successfully complete court-ordered conditions before the case could eventually be dismissed. On paper, it sounds like both sides have reached a fair compromise, but courtroom agreements aren't final until the judge signs off. The big question is whether the facts of this case are serious enough for the judge to reject that recommendation. What would you do if you were sitting on the bench?
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned "Round 2," and this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working in Qdoba. She's aware she owes some money on some older files, but she's going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty verdict. Thank you.
Carnes?
Thank you, Your Honor.
Notice how the tone of the hearing starts to shift. Both attorneys are presenting reasons why this agreement should move forward. The defense highlights the defendant's cooperation, employment, community ties, and lack of adult convictions. Even the prosecutor tells the court that the proposed resolution is appropriate despite describing the incident as deeply disturbing. Normally, when both sides agree, judges often approve negotiated outcomes. But then something unexpected happens. The judge begins asking about prior history, remembers earlier encounters involving the defendant, and starts questioning whether this case truly represents a one-time lapse in judgment. That tells you the judge isn't just evaluating today's paperwork, he's trying to determine whether the recommended sentence actually serves justice. This is often the moment where plea hearings take an unpredictable turn.
This is a disturbing incident involving a defendant and a 14-year-old. Really shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence up to a week.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. The court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Were there charges on that?
She was 18. That was resolved with a civil infraction. I'm just going purely off memory.
This is the moment that changes everything. The judge openly announces that he does not intend to follow the delayed sentence agreement despite both attorneys recommending it. That's a significant decision because it shows the court believes the seriousness of the alleged conduct may outweigh the negotiated deal. The judge points to the age difference, the allegations that the victim was attacked while defenseless, and the reported TikTok post afterward as reasons for concern. He also references his recollection of other court-related interactions involving the defendant, making it clear that he's evaluating the broader picture rather than viewing this incident in isolation. Instead of making an immediate sentencing decision, the judge schedules another hearing and invites both sides to submit sentencing memorandums in an effort to persuade him. Do you think the judge is being appropriately cautious, or should he have accepted the agreement reached by both attorneys?
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge. And I believe she has another case coming up that she has to be arraigned on with Judge Van Olts, because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court, or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug.
What began as what looked like a routine plea hearing quickly turned into a powerful reminder that judges have the final authority over sentencing agreements. Although the prosecution and defense jointly recommended a delayed sentence that could eventually result in dismissal, the judge concluded that the allegations, including the reported assault on a 14-year-old and the alleged social media post afterward, required closer scrutiny before granting such relief. Rather than approving the agreement, the court ordered additional sentencing memorandums and postponed its final decision, signaling that accountability would be carefully weighed against rehabilitation. Cases like this highlight how plea agreements, judicial discretion, and public safety can collide inside a courtroom. Now it's your turn. Do you agree with the judge's decision to slow the process down, or should he have honored the negotiated agreement? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe, Kazafi Says, for more jaw-dropping courtroom breakdowns.